colleagues have made submissions on the issue of bail. I just wanted to go on record that we are not objecting to bail. Maybe on condition that my Vice President ensures that he reports to the investigating officer whenever he is required.
So today, first, what has to schedule tomorrow, you come on 3rd of October. Sorry, no, 3rd of October. You come tomorrow at 2 p.m. tomorrow.
Should we call for a short adjournment so that the court is clear and the person has care?
There are some other rooms on the other side that are bigger and more. No, this is the biggest. Wampeleke the other
Thank you, Your Honor. It is the last time we appeared in the court over this matter. The court had invited me. I was avoiding that because I don't want it to go on record. But it looks like, I mean, at a certain point, we may really need to think about fasting and whatever in the manner that we are. But Your Honor, what I was saying is that the circumstances of the arrest and then demonstrate why. Yes, Your Honor.
Yes, Mr.
Yes, Your Honor. So my final point was that even though it might appear to be an overreach, but this court must look at the circumstances of the arrest, and it will be able to understand that the intention here is for this court to be a convert. We abducted him, we were unable to. So, Your Honor, what I was saying is that this court is intended to be a convert. We abduct or we arrest without any probable cause. We look for any reason and we present a charge sheet and place it before the court. And the court then is supposed to be the one to sanctify, because Your Honor, the moment you accept this charge, and I think if it was a proper charge, we would have no problem, even though we would have known it is finished. But the problem here is that, Your Honor, if you accept this charge sheet, especially as it is framed, and then even this court will eventually almost be on trial the way our police are on trial. You know, for that reason, I'm noting that Mr. Morara had a young counsel that he had instructed ask that you allow Mr. Semonka to just say one more thing, and then I know all of us would want to say something. I'm being reminded it's also a
Please, Your Honor, my name is Baringo. I humbly and really appreciate the information in my last seniors, and I thank them for the knowledge that I've received in the past. However, there's one small thing that we haven't touched. In briefly, that's to do with the framing of charges under Section 134 of the CPC, as read together with Section 135 of the Criminal Procedure Code, which dictates in mandatory terms that a charge must contain a statement of the specific offense in which the accused is charged, and enough information to demonstrate the nature of the offense. Much has been said about civil defamation. However, in brief, Your Honor, when you see count, it refers to cyber harassment under Section 27 of the Computer and Message and Cyber Crime Act. However, when you read the particulars of the offense, specifically line 4, knowingly without lawful cause, knowingly without lawful access, posted false information. That is another offense under the Computer and Message and Cyber Crime Act. Specifically Section 22 of the Computer and Message. If you go on further, Your Honor, they repeated the statement, false again. And then lastly finished with calculated to tarnish calculated to tarnish and discredit the reputation of one David Morara. So, Your Honor, in brief, the question is Morara answering to the charge of cyber harassment or to the charge of publishing false information or civil or defamation? Your Honor, in brief, as I associated both my learned senior and so Eric Theory stated, I was with Morara when he was being arrested. The police refused to grant me access to Article 49, and there are orders that have been given by the High Court that the police ought to respect and ought to follow Article 49 of the Constitution. Some of those orders I personally obtained them from the High Court. Additionally, they did not disclose why they were arresting him or who they were. Some of them were masked. Your Honor, the question is, we are dealing with people.
We might all of us end up fainting here. So please, just a request that you allow me to manage the crowd. I'm going to request everybody after the gentleman in the big camera. We're just going to ask you kindly to step out of the room. Otherwise, we can't face here. Please, you can listen from outside. We have speakers. So we have now, if your problem is that we just want to make because help comes first.
Kutoka hapa tutoke nje tafadhali.
Please. They want to see you can't speak it.
Oh, yes, yes, Your Honor. So,
Because you can get so many of us are sweating. You can get the smell of sweat.
yes, Your Honor, I'll be brief. Your Honor, in
How many
brief,
more minutes will you take?
3-4 minutes.
Okay, please.
Your Honor, in brief, what we are witnessing here as a country is the weaponization of the criminal judicial process against a young man who against all odds stood up to speak the truth. And the truth has hurt many people who are currently in power. That truth has altered the status quo.
Sorry, you are not a witness. You are yet to take plea.
But in brief, Your Honor, history is being made, and I invite this honorable court to stand on the right side of history by quashing these charges and releasing the accused person on personal bond. He is a young person, he is a young person, to release, to free him from this charge. And lastly, as a personal lawyer, I want to thank him for actually believing in a young person. Fellow Gen Z, or fellow Gen Z, and we will stand with him together.
May the court afford exactly 1.5 minutes. My name is Chiel Bradley. It's a privilege to appear before you, Your Honor, in this matter. And just to add to what has been said, the constitutional justification for the cause of action we are requesting you to take. If you look at Article 24, it is a balancing act that the court must strike. And the court must look at the least restrictive alternative. In this case, Your Honor, there is an alternative for the complainant. That alternative is called the Defamation Act. It's sufficient to address any reputational damages. And so there will be justice for the complainant, whichever, if you make the decision we are requesting you to make. And the other one is in Article 23A. That article obligates this court to adopt Article 20 Subarticle 3A. You know, this court cannot interpret the Constitution. That jurisdiction belongs to the High Court. However, this court, as a constitutional organ, must apply the Constitution. And when you look at Article 23A, it requires this court and all tribunals to adopt the interpretation that most favors the enjoyment of rights. In this case, Morara's right to freedom of speech, especially on these issues about. So, Your Honor, there's sufficient legal basis for you to find that this charge does not disclose a criminal case, and that the remedy, alternative remedy of defamation is sufficient. Thank you so much.
Your Honor, perhaps before the
Just a minute. Mr. Ndenge, you want to
Only one about the charge sheet, because it will become relevant for them in response. Only one. Perhaps, Your Honor, to just disclose the bad faith in which this matter has been instituted. That the charge sheet itself is indicating erroneous dates when our client was arrested. He said that they arrested him today. And the fact is that they arrested yesterday. They have a duty to disclose all the material facts, and there is a reason why the CPC requires a date of arrest to be indicated on a charge sheet. Eventually, Your Honor, when you seek to retire, kindly order the DCI office, and this is the DCI himself, to release 3 phones and 1 laptop belonging to our client, as it is charged him. Most obliged.
We just have a brief response. Maybe to just start off, it's the first time I'm seeing Mr. Ndegwanjiro very calm. So it is unlike him. Your Honor, just in brief response, in terms of arrest, it's true the accused person was arrested yesterday and has been produced in court within the required time limit.
Your name for the
Undimu. And has been produced in court within the required time limit. In terms of access to counsel, I did confirm with the officers that he was allowed access to counsel, and the counsel who was allowed was Mr. Ndegwanjiro. And in fact, Mr. Ndegwanjiro did appear at our office today morning. And we confirmed that the charge sheet will be brought. He was accompanied by 2 other counsels, though they declined my invitation. Your Honor, in terms of the charge sheet, the CPC is very clear that a charge sheet must contain 2 critical elements. That is the statement of the offense and the particulars of the charge. Your Honor, my colleagues, my senior colleagues and junior colleagues have not disputed that there is a statement of the offense and the particulars. The contention, especially my senior colleagues have raised, is what is harassment. Your Honor, I look at that particular act, the Computer Nuisance and Cyber Crimes Act. It does not in any way define what harassment is. Harassment takes various forms. One, to draw a conclusion that harassment has occurred. The particulars in the charge have clearly informed the accused person of the accusation that he is facing. And what my colleagues are asking you to do is to go to the substance and the merits of the charges, to go to the evidential material. As at this point, Your Honor,
just one.
As at this point, what court ought to consider that the particulars of the charge have sufficiently informed the accused person of the accusation against him, which in our humble view are sufficient to enable him respond to the charges. To delve into other issues, Your Honor, would be going to the merits and demerits of the particular matter. I do understand the constitutional issue that have been raised by my senior colleagues. And those issues cannot be raised as at this point. The only purpose we are here for today is purposes of the charge sheet, whether it has statement of the offense and the particulars of the offense, and other considerations. Refer this court to section 137 of the CPC. Your Honor, on the last point that Mr. Ndegwa has raised, on the issue of the 3 phones and 1 laptop, I undertake to follow up the issue with the investigating officer to find out if they are interested in the material or the same should be released to the accused person, and undertake to inform him before the closure of business today as to what the response of the investigating officer has been. Luckily, I have Mr. Ndegwa's number. And also Mr. Eric Peuri. Surprisingly, the squatter from Tuapa has not spoken. I'm sure he will respond.
have been invited by my colleague from the DPP. Let the record reflect that my name is Morara, Law Society of Kenya Vice President. Vice President. I joined that. Thank you so
We only respond to the issue of the charge sheet. The other issue are more constrained, as at this point this court only ought to consider whether the statement of the offence meets the legal criteria and whether the particulars of the offence have contained sufficient details. And I've gone to the issue of the harassment.
Martha Karua, SC, leading the defense team. Just to remind the court that our plea is that the charge be dismissed or rejected as defective under 89.5 of the CPC. Our submissions by the various councils point to that direction in adequate words. And it is important that the court only invites the accused to plead to a charge that discloses a course of action. And we have shown the mismatch between the offense charged and the particulars. I need not go beyond that. But when you retire to make a ruling, should you require more time, we urge you to consider releasing Mr. Morara, who is, I'm informed, is an officer of this court, on a personal board. He is, I'm informed he's not an officer of the court, but he is a person who is well known, has a fixed abode in town, and he is not a flight risk. You may consider releasing him on a personal bond. because we must not encourage the behavior of the police of punishing people in advance of appearing before the court. By punishing, I mean detention, unnecessary detention. He is a person who can actually be released on freedom. And we are many, and we will make sure he appears.
I think that should bring it to a close. So you want to bring in this part?
That will be the best approach, but we understand that you may have to read and do some research. And it may not be possible. That is why my learned senior counsel Martha asked that if that be the case, we can ask Mr. Morara to be admitted to free bond, and as it stands, we are
Sorry, Mr. Otieno, now you're out of one. The environment is not conducive. I think I should release it down.
Yes.
The best way to do that is to reserve the ruling.
They will still come tomorrow.
Senior counsel, what has your plan to do? Or what chance would you consider appropriate?
He is a businessman and he is a very well-known, active and engaged citizen. And he's also a lawyer waiting to be admitted. I actually thought he was already admitted. That's why I'm saying officer of the court.
So he can afford a cash bail of 1 million.
Of 1 million, that's in order. Otherwise,
How much cash bail is he able to
that's free bond of 1
Your Honor, maybe Your Honor, just before you kind of, my colleagues have made submissions on the issue of bail. I just wanted to go on record that we are not objecting to bail. Maybe on condition that my Vice President ensures that he reports to the investigating officer whenever he is required.
So today, first, what has to speak tomorrow, you come on 3rd of October. Sorry, no, 3rd of October. You come tomorrow at 2. 2 p.m. tomorrow. Yes.
Is that Thursday?
Tomorrow is Wednesday.
Oh, okay. The court, Your Honor is proposing Thursday the 3rd or tomorrow the 2nd?
morning.
Sorry, the 3rd of October.
That is nasty.
Would we go to 4? Would we go to 4 that will give you enough time in the morning?
See, I'm already confused. So, ruling on the application to be delivered on 4th of October this year at 2 p.m. I know what I'm saying too. I have a very long hearing at the
You can
moment.
take the most of
And the accused person was granted cash bail of Kenya shillings 50,000 with one other person to appear before the court on 4th of October this year.
Why not contract just comes
May I just take this opportunity on behalf of all the advocates to thank the court for the indulgence. Of course, I must recognize that my good friend, Mr. Dim, although he's slipped into town and has not yet performed the usual rituals for us to welcome him into the room, has behaved as graciously as he always has. We understand that they are operating under very difficult circumstances. But, Your Honor, we want to just say thank you for the indulgence and we'll see you on Thursday.
Thank you. We are still here, so if you feel like moving out, please do so peacefully.
Sorry guys, I was shaking because